like John Mikhail and Richard Primus's work in this area, Andrew and David's paper puts conservative and libertarian originalists through their paces. As they remark at the end, applied originalists who do not take theory seriously will miss crucial distinctions, disregard relevant evidence, and misconstrue the very evidence they rely upon. The care with which they identify and apply the technical features of originalist theory is exemplary and to be commended. But my job is to criticize, and frankly, I have more to say that is critical than I can say in my remaining time, so I'm going to have to talk quick. For one thing, as they frankly concede on page 63, they have not been able to, quote, supply all the supporting evidence that would be required to make their account fully persuasive. Moreover, they uncritically rely on the work of Richard Primus. At this conference, I was the commentator on what became Richard's paper in the Michigan Law Review, and I thought at the time that he had significantly overread the evidence surrounding the debate over the National Bank. But there is one important feature that this paper and Richard's article share in common. Neither claims that what they call enumerationalism is inconsistent with the original meaning of the Constitution. Their claim is the philosophically weaker claim that the originalist case for enumerationism is contestable, and that the text of the Constitution was underdeterminate on this point. In short, that the public meaning of the Constitution was ambiguous. Rather than survey all the evidence of original meaning, I will confine myself to making 3 points. The first concerns their claim about the semantic meaning of the text when it is contextually enriched. The second will plow some new theoretical ground, and the third will concern the concept of liquidation. In Andrew and David's discussion of the clauses that are said to support enumerationism, herein granted in Article 1, the word proper in the necessary and proper clause, the 10th Amendment, and the list of enumerated powers itself, they proceed like criminal defense attorneys by knocking down each piece of evidence in turn. Each piece of evidence is counted as 0 if it does not definitively establish enumerationism, and 1 if it does. Thus, each counts for 0. We have 0 plus 0 plus 0 plus 0 equals 0. But that is not the only way to view these terms, these items. Each can be viewed the way prosecutors approach evidence, as strands in a rope. While each strand individually can be broken, taken together they are much stronger. Assume Andrew and David are right that none of these clauses expressly establish enumerationism, but each leads a bit in that direction. If we assign each piece of evidence 1/4, as opposed to 0 or 1, we get 1/4 plus 1/4 plus 1/4 plus 1/4 equals 1. The cumulative effect of all four features helps explain the robustness of what they concede to be, quote, the official story of U.S. constitutional law, from the founding until today, even if they are right that this story is honored only in the breach. After all, hypocrisy is the homage that vice pays to virtue. It is hard to imagine how that official story has been maintained, even in the face of the New Deal revolution, by both the New Deal and Warren Court justices, without the cumulative effect of the text on its readers. In a new paper, Larry Solomon and I discussed the proper role of history and tradition in originalism theory and practice, a topic Cohn and Schwartz are right to say has been under-theorized by originalists. We contend that an unbroken tradition of interpretation from the founding to today can provide evidence of original meaning, and Cohn and Schwartz concede the existence of this tradition. So there is more to the intratextual semantic meaning of the text than they acknowledge in their defense attorney's deconstruction approach to the text. But I don't want to put too much stress on this possibility. I'd rather offer something new for them and for originalists to think about. I want to propose a type of contextual enrichment that arose from the particular communicative context in which the Constitution was debated and ratified. No one denies that the ratification debates are important evidence of original public meaning. Yet when it comes to enumeration, these debates are peculiar. On the one side are the opponents of the Constitution who claim that the Constitution's enumeration of powers is illusory and that the Constitution creates a national consolidation of power rather than a federalist confederation. On the other side, we have the supporters and drafters of the Constitution, like James Wilson, who are said by Mikhail, Primus, Cohn, and Schwartz to be disingenuously insisting that the Constitution enacts the enumeration principle. Call this the Easter egg theory. What is peculiar about this narrative is that the side arguing against the enumeration principle actually likes the principle, and the side arguing in favor of the enumeration principle actually opposes it. Put another way, the anti-federalists would really prefer enumerationism, and the federalists profess to prefer it as well. To put this situation in the numerical terms that Andrew and David do, say the anti-federalists represent 40% of the convention delegates and the federalists represent a bare 50%. Put together, we have 90% of the ratification delegates either favoring or professing to favor enumerationism. That is an overwhelming consensus indeed. But what about the fact, if it is a fact, that 40% of the convention did not believe that the original meaning of the text established what they wished it did? I want to claim that the two sides of this debate are not on equal footing. On one side are the drafters and proponents of a document being offered to the other on a take-it-or-leave-it basis. In contracts, this is called a contract of adhesion. To their credit, Cohen and Schwartz see something like this move coming. They call it an interpretive estoppel argument because its logic is similar to the logic of promissory estoppel. They then dismiss this argument for two reasons. First, because its promissory nature evokes a theory of popular sovereignty that gives rise to the dead hand objection, and second, because this promise-based theory is not based on original public meaning. But they've chosen the wrong analogy to contract law. The concept of promissory estoppel was a bastardization by Samuel Williston of the more fundamental principle of equitable estoppel. Equitable estoppel is about factual representations, not promises. To understand how it works, imagine that before writing a check, you call up your bank to confirm your bank balance. The clerk mistakenly tells you that you have enough funds to cover the check. When the check is presented, however, the bank refuses payment because in reality your account has insufficient funds. The bank then charges you a penalty for the overdraft. The doctrine of equitable estoppel says that you are entitled to rely on the bank's representation of the facts, even if those facts turn out to be mistaken, and the bank is estopped from later denying them. Here, given the potential ambiguity, the public was entitled to rely on the representations of those Federalists who favored and drafted the Constitution, even if the evidence of the meaning of the text was otherwise, as the Anti-Federalists maintain. In this manner, the Federalist representations about the meaning of the Constitution affected the public meaning of an otherwise ambiguous feature of the Constitution. For this to be part of pragmatic or contextual enrichment, the following three elements are necessary. First, enumeration is a natural reading of the text, though not the only one. Cohen and Schwartz and Primus all concede this to be the case. Second, people who drafted the document said it was enumerationist. This fact, too, is uncontested. And third, the public accepted the representations of the Federalists. That the public believed the Federalists is evidenced by the fact that they approved the Constitution over the objections of its opponents, and also by the fact that the opponents of the Constitution threw every objection they could think of against the Constitution, some of which were wildly speculative, thereby undermining their credibility and good faith. This whole process is a process of pragmatic enrichment which established the meaning of the text to the general public. Now, alternatively, the nation may have been divided on this question. To establish this, however, would require proof that the general public believed this meaning to be ambiguous. Assuming Primus is right that some Federalist congressman made this argument after the fact, this is insufficient to establish the existence of public ambiguity. Nor is it enough to displace the original meaning established by the representations of the prevailing party at the time of formation. But suppose, at the time of formation, the text of the Constitution remained irreducibly ambiguous, even so, or that we don't have enough evidence of public meaning to resolve the question. My proposal might then be cast in the alternative as a normative rule of construction to deal with this irreducible ambiguity. For there is another contract law doctrine. It is the doctrine of contra proferentum. Let me quote from a description of how this doctrine works. The contra proferentum rule is a legal doctrine in contract law which states that any clause considered to be ambiguous should be interpreted against the interests of the party that created, introduced, or requested that a clause be included. Contra proferentum places fault on the party creating or introducing an ambiguous contract clause. The phrase contra proferendum in Latin translates to against the offerer, which can be further interpreted to mean guilt of the drafter. Overall, the contra proferentum rule is known for placing fault on the party who created or requested that an ambiguous clause be included. It is designed as a caveat as well as a penalty or legal punishment for introducing and including an intentionally vague contract clause into a document. The underlying idea is that the drafting or introducing party is intentionally using ambiguity to create or provide for results that favor their own interests. Intentional vagueness or ambiguity is an act that the contra proferentum rule seeks to mitigate, and when enforced, rules in favor of the innocent party, citing the ambiguity as unfair. The first step is to review the contract language. I'm going to skip over this and just skip over to the conclusion here, more or less. Contra proferendum is a canon of construction to be applied when the objective meaning of the text is ambiguous. rather than a linguistic canon to assess the objective meaning of the text. Madison made a similar argument in his Bank speech. After quoting the enumerationist claims that Federalists made in state ratification conventions, he observed, quote, "With all this evidence of the sense in which the Constitution was understood and adopted, will it not be said, if the bill should pass, that its adoption was brought about by one set of arguments and that it is now being administered under the influence of another set? And this reproach would have the keener sting because it is applicable to so many individuals concerned in both the adoption and administration." Third and lastly, all this serves to make the liquidation point more powerful than is acknowledged by Cohn and Schwartz in their paper. Assume that the original meaning of the Constitution was irreducibly ambiguous on enumerationism, even after all contextual enrichment. We then have, first, the very public assurances of the Federalists. Second, the widespread political acceptance of this principle, including in the debate over the bank, Richard's claims to the contrary notwithstanding. Third, this liquidation was then confirmed by the Republican triumph in the Revolution of 1800, and four, even by the Marshall Court. Indeed, it is curious that Cohn and Schwartz omit from their paper Marshall's famous articulation of enumerationism in Gibbons versus Ogden. Quote, "The enumeration presupposes something not enumerated, and that something, if we regard the language of the subject of the sentence, must be the exclusive internal commerce of a state." All told, it would seem that any ambiguity in the original meaning of the text was thoroughly liquidated in favor of enumerationism, and the unbroken enumerationist tradition from that day until today only solidifies that conclusion. To sum up, Cohn and Schwartz's paper shows the need for applied originalists to be cognizant of originalist theory. Either there was an original public meaning that resulted from the Federalist representations, or there was an irreducible ambiguity as a result of the Federalist representations that should, as a matter of construction, be resolved against their intended meaning in favor of their representations. And these representations contributed to the process of liquidating any ambiguity in favor of enumeration. I leave to others, to the group, the task of responding to Cohn and Schwartz's claim that under modern originalist theory there was a strong argument that this toothless ceremonial practice, and not the exacting doctrine of contemporary movement conservative imagination, should inform constitutional construction, but I am out of time, probably more than out of time. I close by rejecting Cohn's and Schwartz's claim that the burden of proof in this matter rests on the enumerationists. Rather, I think the burden is on those who would set aside what is admitted by them to be the official story of U.S. constitutional law. But even if it is our burden, in these remarks I outline at least part of how any such burden can easily be met.
I, too, am honored to be allowed to present our paper here and to be allowed to participate by Zoom. I wish I was there in person. I'm stunned that Randy is not thoroughly convinced by our paper, but I'll try to overcome that and respond to a couple of his very perceptive and insightful critiques. I think the fact that Randy is relying on the construction zone and on litigation ultimately to make the case shows that we may have moved the needle somewhat here. I think to say that that the original semantic meaning as enriched by the historical context doesn't demonstrate a determinate meaning of enumerationism is already saying quite a lot. Randy kind of suggests, however, that the equitable estoppel and contra proferentium arguments are both arguments about fairness. And a point that we make in the paper, and I think is right, is that fairness is not a question of semantic meaning or even contextually enriched semantic meaning. If it's unfair to say that there is no money in the bank behind the check, as Randy points out, fairness may dictate that we're going to pretend that there's money and legally say that, but it's not the same thing as saying that there is money in the bank. To say it's unfair to read the Constitution differently from how the Federalists promised it should be read is not the same thing as saying what the words meant to the ratifiers. We kind of had run into word limitations in this paper. We have a separate paper that elaborates on what we call the interpretive estoppel argument. But basically, it doesn't make sense to me to say that we have an original public meaning because it's unfair to read it differently. The fairness argument comes in at a later stage in the construction zone, where we've already acknowledged that there's an irreducible ambiguity. And then once we're talking on those terms, it seems to me that you have to ask, fairness to whom? The fairness argument, at the end of the day, what we're trying to decide is how to interpret the Constitution today. And so, whatever unfairness there may have been to members of the ratifying public who were supposedly taken in by the Federalist rhetoric, who are the successors in interest to that unfairness who have some kind of claim on constitutional interpretation today? In other words, I think my understanding is that once we are in the construction zone, we're no longer talking about some kind of binding, determinate, original public meaning. And then the only other point I'll make to keep it short and move to the Q&A is this. I think Randy is wrong to say that we can make strong inferences about what people believe the Constitution meant based on how members of state constitutional conventions voted on ratification. That's a very difficult question. There are all kinds of possibilities about how people may have voted in spite of an irreducibly ambiguous meaning of the Constitution on the question of enumerationism. They might have decided, I don't like a non-enumerationist Constitution, but I'd rather have this Constitution than nothing. There are various other possibilities that simply cannot be read as proxies for what the Constitution meant to the voters, and we also don't know which voters count. Clearly, there are going to be some Federalists who were happy with the ambiguous Constitution because they wanted to argue for broad national powers. And so what Randy is really talking about is some unidentified margin of swing voters who put the Constitution over the top. And it's, it is not a theory of original meaning to say that the understandings of those particular voters, even if we could figure out what they were, should somehow be binding on our constitutional interpretation.